I think we're all looking for the coffee that Harold had this morning, because that is bringing some energy to some really important discussions. My name's Neil Bradley. I'm the Executive Vice President and Chief Policy Officer here at the U.S. Chamber of Commerce, and I'm delighted to begin our second panel talking about the state of regulation, where we are today and what's ahead. And we couldn't ask for better panelists to help guide this discussion. I think these are all familiar faces to everyone in the room and perhaps most folks who are tuning in virtually. But I'm joined today by David Ogden, partner at Wilmer, Hale, Julia Malkina, partner at Sullivan and Cromwell, and of course, Gene Scalia, partner at Gibson and Dunn. So we are going to save some time for audience questions. So get ready. We'll have about 5 to 10 minutes for that at the end. But we want to start by setting the stage. And so, Gene, I'm going to go to you first. We talk particularly about at the Chamber about over-regulation and excessive regulation all the time. How do you see the current landscape today? Is it par for the course in terms of an administration with this type of agenda in terms of their policy proposals? Is this of a new and different kind? How would you describe the state of regulatory activity today?
Good to be here. Thanks, Neil. I would say that it's sort of a little bit of all of the above. At the end of the day, it's a highly regulatory environment right now, and it will actually get more regulatory in the next few months to year, because we're to a large extent still in the rule preparing and proposing stage versus actually having final rules in place that companies feel the brunt of. But you know, in one sense, it's par for the course, which is that more and more with every new administration, you see presidents turning to their agencies to implement policy for a couple of reasons. One, it's so hard to get things done through Congress. How is a president going to, therefore, satisfy the base, fulfill the mandate? Presidents look to the administrative state to get the work done. Secondly, the courts have encouraged that through Chevron deference, these principles that the courts ought to defer to what agencies say about the law. That has contributed also to this pattern that we see in Democratic and Republican administrations of a flurry of regulatory activity, particularly in the first 2 or 3 years. So that's somewhat familiar. Having said that, the intensity and how aggressive some of the regulatory actions are is new. And just briefly on that, I think one cause is simply that President Biden as president has been more progressive than Joe Biden had been as candidate. That's been remarked in a number of different contexts, but it's certainly true when it comes to the administrative state also. I tell people who want to get a good feeling of how the White House and a lot of the agencies are looking at American business to take a look at the executive order the president issued in July of last year about competition. It's a really dark view of corporate America today. Talks about how there's way too much merging combinations of companies, how that's impairing growth, affecting wages, retarding innovation. Talks about how in the past, prior presidents, and there's reference to both Roosevelts, I think, engaged in, quote, supercharged, quote, antitrust enforcement. And that, in fact, is one area where we've seen a really very progressive agenda. So we see this at the Federal Trade Commission, the CFPB. I think David may talk a little bit about the Antitrust Division, and certainly at the SEC, which has proposed 26 regulations in an 8-month period, according to the Inspector General. And that Inspector General report has talked briefly about the problems that's creating at the agency. So it's a really pretty aggressive regulatory environment right now. And as I say, I think it'll probably get just a little more intense in the next year.
Gene, I'm glad you mentioned the president's executive order. I remember when it came out, we were reading through it, and we're just blown away by the scope and depth of it. I think there are 12 different agencies that received direction on it, 72 concrete actions. You think about, big sectors of the economy, and then somehow they found their way to complaining about the beer industry and the lack of choices that we all have when you're shopping for a six-pack to watch the game. So it is really more remarkable in breadth and scope. David, I want to go to you for a second. One of the things that Gene said is this is in some ways par for the course, right? So presidents are turning to the administrative state to enact their agenda. President Obama did us all a favor when he described it as I have a pen and I have a phone. I remember thinking, that's cool. At the chamber, we got a litigation center. So you got your pen, you got your phone, we got a litigation center. Some of this will play out in court. What's your view of how kind of the regulatory state of affairs is playing out in court today? Everyone's very much following how EPA West Virginia is going to unfold and what that means. But give us your view on the state of play when it comes to litigating overregulation.
Yeah. Well, thank you, Neil, and thanks for having me. I think we've got a kind of a classic clash between an administration that's intent on pursuing a regulatory agenda, and of course, that's why we have elections to establish policy, and a court system that is taking a hard look at Chevron and other sort of core principles of the administrative state. Beyond that, I think there's skepticism, even in more traditional areas of existing laws and regulations on enforcement in the courts. And so I actually think that we're headed towards, we're already sort of in the middle of, but we're headed towards a very active period when these regulations, as they mature and come through the rulemaking process, get finalized of litigation under the APA, which may redefine a lot of the sort of core assumptions in the space. And I think that's just sort of the natural outcome of kind of an irresistible force meeting an immovable object, and I think that's kind of what we're going to see. I mean, of course, the immovable object ultimately has the last word under the system, and so I think that's going to be a big part of the feature. I think when you look at the Justice Department in particular, in general, I think it's an exception to this idea that there is an agenda-driven concern about overreach. In general, I think the people who are running the department in this administration are veterans of the department. They're very committed to the traditions of the department, including the principles of federal prosecution. An area where I think you have to look and potentially see an exception, and this is connected to the comments you were making, Gene, is in the antitrust division space where they've suffered. They just won a merger case a couple days ago, but they had lost 3 or 4 very recently where they were pushing the envelope, challenging mergers in the context of horizontal labor market agreements. They've lost big criminal cases where they chose to bring criminal enforcement to try to move the law. That actually was carrying through on investigations that had been approached that way in the Trump administration. But this administration pursued them. This antitrust division, I think generally, if you want to move the law through enforcement, civil is usually the way to go first. Establish the principles, and then you can sweep in when you've given notice and established scienter. But that's not how they proceeded, and I think they kind of reaped the whirlwind there. I think the problem for the department, I think it's fine to bring righteous cases, even if they're tough cases. The deputy AG has said that should be the way that the department proceeds. The AAG and the antitrust division has said that. That's fine, of course, if they meet the principles of federal prosecution and merit the use of resources. That's, of course, fine, should be the case. But the department pays a cost as it loses cases in terms of its credibility with the courts and its credibility in the business community. And so I think, there has to be, together with that willingness to bring those tough cases, and I'm not saying there isn't, but I think there really has to be a consideration of sort of the institutional costs of proceeding in what I would say is a risky fashion.
Dave, I want you to spend another minute on this. You talked about in the context of the antitrust, and we've obviously seen all of those cases. Are you seeing also a willingness, maybe in other areas of DOJ, to pursue cases that maybe don't meet the standard that you just laid out, or is this really isolated at the moment into some of the antitrust enforcement?
I mean, I think in terms of the actual experience when you're looking out there at outcomes, I mean, look, DOJ is not always going to win every case it brings, and you know, we wouldn't expect that in a country where the courts are free and independent. We would want that, I think. But by and large, I think, at least my sense of it is that where we've seen it primarily is in antitrust, where there is an effort to move the law, I think. I think beyond that, while the DAG has said, while the Deputy AG has said, we should be prepared to bring these cases even when they're difficult cases. At least, you know, my experience is I don't see anything out of the ordinary.
So, Julia, I want to bring you into the conversation. Maybe we can start by diving into one of the agencies that got a lot of attention in the last panel, and the SEC and what seems to be kind of a torrent of fast-paced proposals coming out of the SEC. Is that the right way to look at it? Can you help us put it in context, what the SEC is trying to do now relative to what it's done in the past, and how big of a concern should this be to our audience?
Thanks very much for having us, Neil. So I think by any standard, the SEC's regulatory agenda has been ambitious. Since the start of the President Biden administration, we've seen proposed or enacted rules on a wide range of subjects, ranging from climate-related disclosures to board diversity disclosures to ESG fund names and ESG fund disclosures, cybersecurity, SPACs, universal proxy requirements, proxy voting, shareholder proposals, insider trading, Rule 10b-5 plans, and the list goes on. You know, I think the regulation that's been proposed that's had the most attention from the business community is the climate-related disclosure regulation. And I actually have a statistic for that. So the climate-related disclosure regulation has received the most comments in history during the notice and comment period. And that's not even taking into account the reopening of the notice and comment period last month. So I think that regulation is one where we've really seen a lot of attention. And in the comments, we've seen attention both to specific provisions of the regulation and their scope and application in practice, as well as their consistency with regulations coming from other places in the world, which is a concern for multinational companies that are subject to both regulation in the United States and especially the European Union, which has been ahead of the United States on some of these issues. But we've also seen a number of comments that are really focused on the agency's authority to promulgate such regulations. Also focused on the definition of materiality and whether the regulations are consistent with common understandings of materiality, both quantitative and qualitative. Also, the rulemaking process itself with respect to this regulation. So we've really seen a wide range of comments. I think three of the areas substantively that the comments have focused on are first Scope 1 and Scope 2 emissions, so direct and indirect emissions, which under the proposed regulations, companies would be required to disclose regardless of their materiality. So that's a portion of the proposed rules we've seen a good amount of comments around. A second portion is Scope 3 regulations, so indirect regulations further down a company's value chain that a company doesn't control. Here, under the proposed regulations, a company would need to disclose Scope 3 regulations in two instances. One, if they're material to the company's operations, and two, if the company has announced goals or targets with respect to emissions that include Scope 3 regulations. Now, those have become increasingly common, regardless of the materiality of Scope 3 emissions to a company. Those types of goals and targets have become increasingly common throughout corporate America. So many companies would come into that requirement under the proposed rules, not necessarily through the materiality standard, but through their goals and targets. I think the third area that we've seen quite a bit of comment around is really the requirement for disclosures about financial implications if they are material at a 1% threshold to an individual line item in a company's financial statements. So that's below what is commonly thought of as the threshold for materiality in this context. So that's, again, a place we've seen a good amount of comment. I think one thing, we have the regulatory rulemaking side of things, and then we have the enforcement side of things. On the enforcement side of things at the SEC, we have in fiscal year 2021 a slight increase from fiscal year 2020 on the number of standalone actions, but actually in fiscal year 2021, a lower number than in 2017, 2018, 2019. With respect to total financial recovery, we're also seeing something that's broadly in line with the 5-year average. 2021 was below 2020. 2022 numbers should be out any day now, so we'll continue to track how that progresses throughout President Biden's administration. But I do think really the focus has been from the business community on the rulemaking side of things. And I think, consistent with that and announcing the 2022 spring agenda, Chairman Gensler said, no regulation can be static in a dynamic society. So I do think that that's an area where we have seen quite a bit of activity.
It's an interesting comment from the chairman to parse in terms of thinking about what that would actually mean in practice. Gene, you're doing a lot of work in the SEC and the climate disclosure space. How do you see the interaction and the impact on companies?
Yeah, it's actually a really interesting rule to talk about for just a minute more, because it reflects a couple of broader trends. One, we've obviously been talking about just the volume of proposed regulations from various agencies, but this is a good example of how aggressive some of these regulations are. There had been a number of entities that wanted to see the SEC do something in this area, but even many of them were taken aback by how far this particular proposal goes. The SEC's own cost estimate is that the disclosures under the climate rule would cost companies nearly 2.5 times what all of their other current disclosures cost them, which is, an extraordinarily burdensome rule, and I and others believe that actually understates the cost. But at the same time, they're saying, well, and this is not necessarily material. And so you just pause and say, well, wait a minute. You're going to adopt the most burdensome by far disclosure rule ever for stuff that may not even be material. Why would you do that? And so it's an example of how far things are being pushed. I mentioned earlier in the competition order the president put out, he talked about things in Rooseveltian terms, and some of the antitrust enforcers, particularly the head of the Federal Trade Commission, Lena Khan, is associated with what's called the New Brandeis School of Antitrust. So we're harking back to Roosevelt, Brandeis, that kind of thing. The problem, I think, for the administration, David touched on it, is that Roosevelt, particularly Franklin, had a huge congressional majority and acted through legislation. Brandeis is a leading figure of the progressive era, where the courts were in a different place. Now we have courts that are actually, even as the administration is taking a really big, grandiose view of the administrative state, you have a Supreme Court that's more focused than I think the court probably has ever been, at least going back to the New Deal, on questions of administrative law, and is taking a really skeptical view of the administrative state. And so I think to some extent you've got a set of rules coming out of agencies that were built for another era and really will encounter some serious problems in court. Until pretty recently, David will remember, you talk about ad law, people would just get bored to tears, but suddenly administrative law actually is interesting to people. And I think that's in part they see this coming clash.
It was always interesting to this group, to be clear. I'm glad you brought the Neo-Brandesians. If you really want to understand this, you want a quick read on it, everyone should read Tim Wu's book, The Curse of Bigness. It's a quick read. Understand he's running all of this out of the White House now, but if you believe in free markets, it's kind of on the Halloween reading list in terms of this. You have to be prepared for pain. Exactly right. So we've set the stage a little bit about the present, but let's turn the page and think a little bit about the future. We're 6 days away from a midterm election. There's lots of speculation about you mentioned big majorities. The president's party may not have a majority in one or both houses of Congress in a couple of months. David, does that portend any changes on the regulatory front, on the enforcement front? Will the next 2 years look any different, or how should we think about how they might look differently than the current state of affairs?
Well, I just think, yes, I think it changes things, because I think if there is a Republican majority in really either house, I think it takes whatever faint hope one might have had from the Democratic side of getting legislation passed largely out of the picture. And so I think that changes things. Gene was alluding to the challenges that exist anyway, right? But particularly in that context. I think you'll see a maturing, as we've also alluded to, of the rules that have been put in motion in the first 2 years of the administration. Those will come into finality. There will be challenges to them. Some of them will survive, I presume, and you'll begin to see invigorated enforcement under those rules. I think you'll also see, I think, sort of a natural gravitation toward enforcement of existing rules that aren't so easily subject to administrative law challenge in the courts. Again, I think that's the natural evolution. We saw it in the Obama administration. I think you're likely to see it here, because those are the tools that exist. I think at the Department of Justice, I really don't think that you're going to see a use of the tools of the department in any sort of a political sense. I think you'll continue to see the new Brandesian, is that how you pronounce it? In the antitrust division, pursue things as he has been. But I think outside that area, I think what you'll see is pretty much business as usual for a Democratic administration in the next couple of years. Oversight will be intense in an environment in which Republicans control one or both houses. That has consequences if you're there, for sure, because you've got to play a fair amount of defense, and the tensions between Congress and the administration, particularly in the enforcement space, are very difficult, because oversight in the enforcement space is a particularly fraught subject. Quite legitimately, the administration will be resistant to sharing information, and quite naturally, the Congress will be very aggressive in seeking information. But I think we'll see all of that playing out in the ensuing 2 years, if that's the space we're in.
Now, we're about to get to audience questions, but before we do so, Julie, I want to spend a couple minutes exploring a topic we haven't covered yet, and that is there seems to be a kind of a remarkable spate of challenges to the structures and processes of some of these administrative agencies we've talked about. I think it was the Fifth Circuit on CFPB funding. We have cases on the FTC. We've had cases on SEC. Do you see continued challenges to the structures in which these agencies operate? What will that mean, if anything, for the regulatory and enforcement framework going forward?
So I think this whole conversation that we're having is part of the challenges, but it's also the challenges are a backdrop to the conversation. The challenges are interesting in the sense that they don't start with President Biden's administration by any means, and they're to aspects of the structure and processes of these agencies that are longstanding. So in the last 4 years, there's been 4 major decisions with respect to the SEC alone, starting with the Supreme Court's decision 2018 in Lucia, which was a 7-2 decision written by Justice Kagan, that held that these SEC's administrative law judges, or ALJs, are inferior officers and thus subject to the Constitution's appointments clause and must be appointed by the president, a court of law, or the commission itself. And what the commission did was ratify the ALJs that had been selected by the SEC staff and reassign cases to them and restart cases. And then you had Liu come out in 2020 from the Supreme Court, that 8-1, a Justice Sotomayor decision, and a challenge to the SEC's disgorgement authority. And there, the court held that yes, the SEC has statutory disgorgement authority, but that there's equitable limitations to that authority. So, you can't ask for disgorgement that's more than net profits, for example, and disgorgement must go to wronged investors as opposed to the Treasury. And after that, you had Congress pass an amendment to the Exchange Act that broadened the SEC's disgorgement authority and other authority as well. And you've seen these challenges really, I think, speed up in the last couple of years. You have a decision out from the Fifth Circuit on the SEC side of things, where the Fifth Circuit en banc held that individuals in ongoing SEC enforcement actions could bring structural constitutional challenges in district courts. Supreme Court will hear argument on that on Monday, along with a companion case with a similar issue from the FTC perspective, whether you can bring structural constitutional challenges to ongoing FTC actions. Then I think in the last month or so, we've had particularly significant decisions coming out of the Fifth Circuit. So one, the en banc Fifth Circuit declined to review a case called Jarkowski, where the Fifth Circuit held that the ALJ process in the SEC violated the Seventh Amendment's right to a jury trial. So I think that's probably has the broadest implications of all of these decisions thus far. I think that's likely to have Supreme Court review next term. Also a decision out of the Fifth Circuit last month holding that the CFPB's funding structure violates the appropriations clause because CFPB is funded through the Federal Reserve as opposed to through Congress. That decision we expect a petition for rehearing at the full Fifth Circuit level, and if the Fifth Circuit either doesn't grant en banc review or affirms that decision, likely up at the Supreme Court as well. So there really has been a significant number of these structural challenges that we're seeing to both the procedure and the structure of the agencies themselves. And there's others percolating in the lower courts, so I don't see these slowing down. I think when we think about their ramifications, it's really a case-by-case approach. So for example, if Jarkowski sticks with the Fifth Circuit held, a right to a jury trial with respect to SEC enforcement proceedings, that really has a very significant impact on the ability of the SEC to bring administrative proceedings at all.
Excellent. All right, let's open it up to audience questions. Brackett.
My question for all of you, and Julia, you focused on this a bit, is what can we do about it? And what you said correctly is we can litigate a lot. So we all get concerned about the Department of Justice and antitrust, but they've got to go persuade a judge that they're right, and that's our best protection. That is our best protection. What's more problematic is something like the FTC, which can establish new standards, change all the rules about what they will do. That's much more of a worry to me. And then when it comes to the SEC, same question. We're just going to have to litigate whatever we can litigate as best we can. We don't have any other tools there. Am I wrong? Or are we missing something that we should be pursuing?
I do think we're going to see a significant increase in litigation, especially also as the Supreme Court has issued decisions that may move the guidepost with respect to administrative law as well. And Jean spoke about this a little earlier, so I do think litigation is something we're going to see quite a bit. I think a broad scope of players in corporate America have also been heavily involved in the notice and comment processes before these various agencies, and I do think that's an important part of engagement. And I think sometimes companies that haven't been significantly involved in the past in notice and comment have been coming out with respect to some of these more recent regulations and making important contributions through that forum as well. And with respect to the climate disclosure rule, for example, one of the things that's been said with respect to its timing is, the real focus that we've seen in the notice and comment period is one of the things that from all parts of the political spectrum, folks have said this is a record number of comments and the SEC needs to consider and respond to them in a fulsome manner. So I think that's also something that is out there in the toolbox as well.
So 2 quick points on litigation. There's litigation and there's litigation. There's defending enforcement actions, which is defensive, and you got to do it if you're on the business end of an enforcement action. And when you're talking about the Justice Department, usually that's what you're talking about. But there's also proactive litigation. I know Gene will agree with me about this. There are Administrative Procedure Act challenges that we've been talking about, which are affirmative tools that exist for the business community or any regulated entity or person to challenge new rules affirmatively before they're enforced, and that is a proactive tool. And then the second point that I'd make is that obviously oversight, which I mentioned earlier, particularly in the area of rulemaking and policy setting, is a real tool in the hands of the Congress. It's a less effective tool, and it should be less effective, in my view, in the actual enforcement setting. But in the context of policy, in the context of rulemaking, all of that, Congress does have a lot to say about that and should.
Just a very quick observation on litigation. Yes, we will see, I think, a large number of rule challenges. The big question in my mind is whether companies, when they're defendant, will stand and fight more than sometimes they have in the past. The CFPB, the Federal Trade Commission, have made a lot of law over the years by getting companies to knuckle under because they didn't want the reputational hit of that enforcement action by the agency. But as those agencies push the law more and more, the question in my mind is, will more companies say, sorry, we just can't go that far with you. We're going to have to defend ourselves in court. Because as we've seen in some of these cases, one involving, for example, the Federal Trade Commission's authorities, when the companies have stood and fought and said, no, your understanding of the law is just way off the map, they've won. And I think if the agencies keep pushing too far, they'll get more defense from the companies, and other companies will, in light of that, also be more willing to stand up. So that's a trend I'm watching for.
Unfortunately, we're going to have to leave it there with questions, but let me just say that none of this regulatory overreach, none of this enforcement is happening in a vacuum. As we've discussed today, there's a concerted effort to build momentum. There's a strategy around all of this, and the Chamber and our Institute for Legal Reform are dedicated to providing the counter pressure and the counter narrative that pushes back, whether that ultimately leads up in court or the halls of Congress or in the court of a public opinion, and pushing back against this regulatory onslaught. So please join me in thanking our panelists today. I believe they'll be around in additional questions.